Good morning, everyone. Today is Monday, May 2nd, and uh, as you know, we have our monthly Child Support Connection event on the first Monday of every month from 11:30 to 12:30. So I'm happy that we're able to come back together and talk a little bit about some of the things that we're doing here in the state of Delaware for child support services. And as we continue to have this event over the next hour, if you have any questions, feel free to put them in the chat, and I will do my best to try and answer those questions. That's one of the great things about having this each month is it gives individuals an opportunity to look at the videos that we're posting to our Facebook page. And if you have questions that come out from that, the previous videos, or if you've had a discussion with your child support specialist or another employee here at the child support office and you have a question or you need some further follow-up, you can certainly post that question in the chat, and I would be more than happy to give an answer to the best of my abilities to try to help out your particular situation. And we certainly appreciate anyone who watches this video after. We actually post it not only to our Facebook page, but we have a YouTube channel that there's probably about 10 to 15 previous child support connections posted, and some work that I do with Jake Smith down at 92.7 on our monthly radio show that talks about child support here in Delaware. And we post those discussions to our YouTube channel. If you haven't seen it or had a chance to look at our YouTube channel, I'm certainly encouraging people to check it out and subscribe to it and share it with as many people that you want that may have or need some help with child support here in Delaware. You know, one of the other things and that I like about what we're doing with this Child Support Connection is, non-custodial parents in the state of Delaware have a place to go to get information regarding child support. As you probably suspect, we hear from non-custodial parents a lot that they're suspicious of the system, but we're really trying to break down those barriers and try to help them have a better understanding of what the child support process here in Delaware is, and how they can, as I usually say, maneuver through that child support system, whether it's at the child support office or at the family court here in the state of Delaware. So if you know someone who has a child support obligation, I strongly encourage you to share with them our Facebook page and our YouTube channel, and give them that resource that maybe they can find some information that will help them. I also always like when we start these monthly events to give the customer service unit telephone number. So if you have a question about child support in Delaware, you may not even have a child support case, but you have a question about child support in Delaware, you can always call 302-577-7171 and speak to a child support specialist, and they are experienced folks that can answer your specific question. We have bilingual child support specialists that are also in the customer service unit, and they can help those who are non-English speaking folks. So it's 302-577-7171. So that's for our customer service unit. The other thing I always like to do, and I know it kind of might sound a little quirky or whatever, but I always like to read our mission statement, because the mission statement here at Child Support, we actually changed it a couple of years ago when we changed our division's name from the Division of Child Support Enforcement to the Division of Child Support Services. So I always like to read our mission statement, because it's important to me that both custodial and non-custodial parents understand what we're really trying to do as we support families in Delaware. So it's our mission at the Division of Child Support Services to deliver quality customer support by partnering with parents to improve the lives of their children and the family unit. We achieve this through obtaining accurate child support orders to meet the financial, medical, and emotional needs to promote family self-sufficiency. The Division of Child Support Services is one of 12 divisions within the Department of Health and Social Services. Our mission as a department is to try and help individuals, and in our case, help families, become self-sufficient so that they can support themselves and support their families and their children. So when we talk about self-sufficiency, it's not only talking about custodial parents being able to support their children, but really it's a movement to try and help non-custodial parents who have a child support order to find employment opportunities that will make them self-sufficient, to make the non-custodial parent have enough money from their earnings to live, in addition to being able to pay the child support orders as established by the family court. That's important to us because we don't want to see anyone in the state of Delaware not be able to financially support themselves and their families. And if the custodial parent and the child are receiving state benefits, that hopefully the amount of income that non-custodial parents and custodial parents begin to earn, and more money that goes into that household can get that custodial parent off temporary assistance to needy families, or remove them from the Medicaid system and have private insurance cover the children in the family unit. So we are really working very hard to ensure that we work with custodial and non-custodial parents to become self-sufficient. And we really try to do this to make the family unit whole, as well as trying to reach the best outcomes for children here in the state of Delaware. So I know it sounds a little hokey or whatever, but I always do like to read that mission statement because it's important to me, and I think it's important to the people we serve, that they know what our goal is and what we're really trying to do to help families here in Delaware. So I just wanted to make sure I did that. And ultimately, what I'm going to try and do as we move through today's Child Support Connection is if there's questions, I'll jump right to those and answer them. But I also like to always talk about certain things that we're doing here at Child Support to promote the program. We do have what we call a Speakers Bureau. And that Speakers Bureau, prior to the pandemic, would go to community events, health fairs, job fairs, and pass out literature about the child support program here in Delaware. And finally, with some of the pandemic issues behind us, the nicer weather coming, coming with the spring and summer, I'm really looking forward to getting back out into the community and sharing child support. So, if you know of a community event that you're that's coming to your neighborhood, or if or if you're the one that's planning that community event, you can always contact us at the Child Support Office or send us an email, and we would certainly consider attending a health fair or a job fair to promote some of the things that child support is doing here in Delaware, and try to talk to custodial and non-custodial parents about how we can make their child support situation a little bit better. And I see that we have a question, so I'm going to go ahead and read it. There's actually a couple questions, so that's great. Keep those questions coming. So first and foremost, quick question. I put in for a child support order for two different fathers. The first father had an old address for him. They were able to locate him. And we had a mediation that he didn't show up to, but they said they were able to attach his wages. Which is wonderful, great. But the second father, let's see here, I know his current address, and they are saying that they cannot serve him or find him which is so confusing because that is his residence. Please help me understand the process. Okay, so let's see here. Okay, so whenever child support starts a child support case, that first petition that we file with the family court, it's a petition for new support. In order to obtain jurisdiction over the non-custodial parent or the putative father or the other parent involved, service of process actually has to be in person. So we have a relationship with a service of process company that actually has to go out and personally serve that petition to the non-custodial parent or putative father. They will attempt service several times before they basically say we have to return that petition to family court for non-service, and that's what's happening in your particular case. They're saying we've tried at the designated address that child support is provided, and we are unable to serve the other individual at that address. So they're not necessarily saying he doesn't live there. They're saying that when they went to serve him, and we do try to encourage the service of process company to go at different times of the day, or go, in the evening to try and serve the non-custodial parent, and to try and tune in on different times of the day that person may be there. So when situations like this occur where they have not been able to serve him, what we try to do is gather a little bit more information to provide to them. So and sometimes, I'm on record as saying this several, tons of times before, we can't do our job at child support without the custodial parent's information or providing us with information. So what I would like to recommend to this, so that service of process has to be done personally that first time, and then once that's done, all future services or serving him or her for the next court hearing happens by regular mail, just sending the notices to the last known court address that we were able to serve the person at. So when we're not able to serve the person, we sometimes go back to the custodial parent and ask for some additional information. Because I certainly, in your situation, believe you that, hey, that's his address. So what we do sometimes is ask for a photo of that non-custodial parent. Sometimes we use Division of Motor Vehicle Records. Sometimes we ask for information about what color car does he drive and what kind of car is it. Do you have his license plate? And in those situations, we will then provide that additional information to the service of process company. And they will use that to kind of zero in a little bit better on trying to serve that non-custodial parent. In some cases, employers will let us serve that non-custodial parent at their place of employment. Sometimes they don't let us do that. They kind of want to stay out of that situation. So what I would do is this. I would encourage you to contact our child support office, speak to a child support specialist, and provide them with any additional information that you may have. And we will turn that information over to the service of process company. If you want to send us a personal message, you can do that with your case number, and I can have the worker contact you, and you guys can have that conversation about more information to help us get him served. But it's always that first petition. We have to serve it personally to that non-custodial parent, and then after that's done, we have jurisdiction over the individual. Okay, the next question. How would you suggest I proceed with my ex-husband's arrears balance that are over $111,000 for child support? Well, what I would do is this, and this is just, this is a general question, and man, when I see that balance in arrears, that's really troubling to me. As a child support director, as a former child support specialist, supervisor, being in the child support program for all these years, man, I hate to see arrears balances that are that high. One of the things, and so I said I don't have a lot of obviously specific information, and I don't want you to put that in the chat, But what I would suggest is this, and there's certain things that a caseworker can do. And we've talked about some of the automated enforcement tools that we have at Child Support that automatically trigger. And I'll just run through them real quick. It's that license suspension program. It's that tax intercept program. It's, reporting people to credit bureaus. But there's no enforcement tool that works for every case. So, like for instance, we may be able to suspend a driver's license, but the person may choose to drive on a suspended license rather than pay child support. We can submit him or her for federal tax intercepts. When they're going to get a tax refund, we can intercept that to pay off the arrears. If they don't file taxes and they're not going to get a refund, we can't. No, that's not going to work. So there's no there's not every enforcement tool works for every particular case. Now, what I would suggest you do is this. I would contact the child support office and speak to your child support specialist. If there's a way that we can file a petition, a contempt petition for non-payment, we will do that. There may be, in some circumstances, there's capias. If there's a family court capias, because he failed to show at a previous hearing, we can't generate or submit a new petition until that person is brought into family court to answer that capias civil bench warrant on that previous petition. But it couldn't hurt, and I'm sure you're probably doing this, but it couldn't hurt if you're not doing it, to reach out to your child support worker, child support specialist, and have a conversation. And it's okay to ask, hey, what enforcement tools have you guys done for me? Like what's currently in place? And just to find out, have we submitted him to tax intercept? Have we suspended a license? Have we done everything that we can do? And find out what we can do to get him back into court to answer to the fact that he's got that large arrears balance. But I would definitely suggest speaking to your child support worker, and it's okay to ask the questions. What have you done for me? What enforcement tools have been put in place against this non-custodial parent? And we'll certainly tell you that, and find out what next steps based on your particular case situation that the worker can put in place moving forward. The next question. I have a question when you get a chance to answer. If a child graduates high school a year early at 17 and goes straight to college, does the non-custodial parent still require to pay child support? And if so, is there a way to allow the money to go straight to the child instead of the mother? So in Delaware, in this particular scenario, if the child is still 17 and graduates from high school, the non-custodial parent is still required to pay child support until the child's 18th birthday. So in your particular situation, child support, the current support obligation, would end when your child turns 18. Any arrears that are owed would be continued to be paid off on by the non-custodial parent until those arrears are paid in full. And what we normally do is we will ask the court, when that current support ends, to convert that current support amount, add that current support amount to an arrears payment, so that the wage attachment continues to be sent at the same dollar amount until that arrears balance is paid off, and then the whole obligation would be over. But if the child is still in high school when they're 18, child support would end when the child graduates from high school. And then if they're still in high school at 18, all child support ends at age 19 here in the state of Delaware. And thank you for writing that question. That was a great question, and I really appreciate it. Let's see here. The next question. Keep these questions coming. This is excellent. Let's see here. So much better than many years ago. A lot of had no support at all. Thank you for doing more nowadays. Thank you. Thank you for your writing that. What a wonderful thing you're doing, hosting this live. Yeah, this is thank you both. There's two of you that said you're great that you're happy that I'm doing this, and I'm happy to be able to do this. And the best thing you can do for me is to encourage other people that you know to chime in. If not this month, next month. We're going to continue to do this each month, and we love the questions, because if you have this question, you know, and I know that there's other people out there that have this question too. So have a question about their child support situation. So keep those questions coming. And here's another question. For child support help nowadays, do you help with it no matter the non-custodial parent's income, or do they have to qualify for let me read that over again, sorry. For child support help nowadays, do you help with it no matter the non-custodial parent's income, or do they have to qualify for Medicaid? Okay, great question. So a couple things here. We will, so if you are someone who wants child support or needs child support here in the state of Delaware, and quite frankly, all child support agencies around the country, we will open a case for you if you have a child. You do not have to have you do not have to be a Delaware resident. You do not have to be a legal citizen of the United States. You just have to have a child, and we will open a child support case on your behalf. As it relates to the non-custodial parent, the non-custodial parent does not have to, whatever their income is, we will work with them and the custodial parent to get a child support order. They do not have to be enrolled in any kind of state service or getting any state services, and we do it all the time. We go after non-custodial parents who are not receiving state services whatsoever. So now, if a custodial parent goes to the Division of Social Services and receives Medicaid or TANF for the child, we automatically get a case from the Division of Social Services, and we work that case. That's one of our responsibilities, is to reimburse the state of Delaware through child support collections from the non-custodial parent to pay back TANF benefits, or to get an order for child support for medical insurance coverage when the child is receiving Medicaid. So we automatically get a case. But if a custodial parent is not receiving Medicaid or not receiving TANF, we have an application that individual can fill out, submit to our office, and we will create a case on their behalf. So when you do fill out an application, there is a one-time $25 application fee, and that application fee provides you all of the services we have at the division, all of our enforcement tools, all of our filings with the family court. We have our Attorney General's office represents custodial parents in commissioners' hearings. So there's a whole bunch of services that we provide for that $25. So if the custodial parent is not receiving TANF for Medicaid, we can go ahead and start a case on their behalf. Let's see, I got a question handed to me, so I'm going to try to read this. Isn't an arrears that's large a federal felony? Okay, so the question that I got handed to me is, when we talk about those arrears that are $111,000, the question that came to me is an arrears balance that large a federal felony? There are certain things that can happen at the federal level as it relates to enforcing child support obligations, and there can be some interaction with federal authorities when we are dealing with large arrears balances. However, there's certain things that we have to prove in order to get the federal government to assist us. And without knowing the specifics of your case, I could certainly we can certainly look at them. One of those things is when we talk about the ability to pay and whether the non-custodial parent is truly absconding from paying their child support obligation. And so I mean, there are certain things that the federal government can assist the states to do, and we can certainly take a look at that situation as it relates to helping with using the federal government. One of the other things too that just occurred to me too is we have to kind of prove that that non-custodial parent has left the state of Delaware, has jumped to a different state to avoid paying that child support. Some of the things that we have to do to prove to the federal government is they are very it takes a little bit to try and prove certain things that to make it go to that next level. But we can certainly take a look at that. I'm going back to the questions. Great. Yes. Thank you. Please share it. That's awesome. How often should a child support case be revisited? So that's a great question. So when a court order is created for child support, in Delaware, we are a judicial state. So the family court here in Delaware helps us create those child support orders. And the Federal Office of Child Support tells the states that every 2.5 years, we should be looking at a case to see if it warrants a modification of that existing order. And we are required to notify custodial parents that, hey, your order has reached that 2.5-year limit. We want to take it back to family court for a modification, and we need some information from them to help us make that happen. When we file a petition at family court, we always alert our custodial parents that that obligation could change. It could go up, it could go down, but we always like to make the custodial parent aware of that the order is going to change one way or another, but it's based on the financial circumstances of both parents at the time. Now, either parent could say to us here at Child Support, or the non-custodial parent could go directly to family court and say, I have a substantial change in my financial situation. I've lost my job. I got a new job and I'm not making as much. I got a promotion, or he got a promotion, and we can file a modification if there is a substantial change in a person's financial situation. And we kind of base that on a 10% increase or decrease. So, we can do a Melson calculation. The Melson calculation is how the courts determine what that obligation is going to be. The calculation is on the family court's website, and we just, we get the financial information and plug it into the calculation, and it tells us, hey, is it going to be 10% more or 10% less? And that kind of tells us whether a modification is warranted. So every 2.5 years, though, we like to take that look and see whether it's time to have a new order put in place. But anybody can do it at any given time. Next question. Just some comments here. That's fantastic. You help no matter what. I love that you. Let's see, it keeps jumping on me. I'm sorry. Let's see here. I love that you are doing this for children, because that's what children's support it's for. Thank you for all of your changes. Excellent. Thank you so much. The follow-up to that application fee, no matter the hardship, a $25 fee can't beat for helping. Yeah, I mean, yeah, I totally agree with you. The $25 really does get a lot of activities and a lot of services. So, I always try to encourage people that if they need help, to apply for services. The one thing I forgot to say about that $25, if the custodial parent was ever on TANF, or ever on Medicaid, say they came from a different state and they were on TANF in that state, we would waive that $25 application fee. So there are some things we can do to help custodial parents who need services to get those services. And the other thing too, I'm glad this whole thing came up about the application process. You know, we are working closely, and I mentioned this last month, we are working closely with Head Start and early educational child support, early childhood education programs here in Delaware. If you know someone whose child is in Head Start or an early education program, we will waive the fee for child support. So you know, we're encouraging people to do that, if they're in those programs, to apply for child support if they need it. What are the resources for custodial parents when the non-custodial parent is incarcerated? Another great question. Are the income guidelines, or is there help anyway or not? So when a non-custodial parent is incarcerated, we still will accept a case and we will still work that case. And you know, there's things that we do as it relates to paternity establishment, establishing paternity for children born in Delaware, that even if they're incarcerated, we can have genetic testing done. The courts have ways of working with the correctional centers here in Delaware to do video conferencing. And the courts will create a child support order for someone who is incarcerated. Now, granted, those orders are going to be minimal. They're going to be small amounts, but it does put that person under an order to pay child support and hold them responsible for their children. So, and in some circumstances, when the person is like at a level 4 correctional center in Delaware, you know, those are work release. They can still go out and work. We can still attach those wages, and they're paying their child support obligations. So we do work closely with individuals who are incarcerated, and they do have income guidelines at family court based on, even when someone is unemployed, you know, they will put an order in place. Like I said, it'll be probably for minimal amounts. I feel like I need to speak to someone above my caseworker. How can I do that? So what we always try to encourage, I'm not foolish. You know, I certainly understand that custodial parents and non-custodial parents may call our office, and we do try to provide the best service. But I'm no idiot. You know, we sometimes don't meet that. We don't meet that level of activity. So, you know, we always like to try to do this. Is we always like to encourage people to speak to their child support specialist first. And if that doesn't work, you know, we do encourage people to ask to speak to a supervisor. You know, our supervisors are very knowledgeable about the child support system, and we like to have custodial parents or non-custodial parents who are calling our office work up that chain, and I'm confident our supervisors, you know, they step up and they really do know and can guide people through the child support process. So if I would just recommend calling our customer service unit. They will hook you up with your worker, and I encourage people to do that first. And then if you don't feel like your questions were answered, you can certainly speak to the supervisor and then work your way up. But try to really work with the worker, the child support specialist, and then to speak with their supervisor, the child support supervisor. And our customer service unit number is 302-577-7171. So if the court doesn't file a modification on 2.5 years and significant changes have happened, the guardian should refile. So, and let me back up a little. If you are if you're a client of the divisions, you should contact our office and indicate that, hey, the order is over 2.5 years and I'd like a modification. Non-custodial parents, they can ask for the same thing, but they would contact the family court. In each of the family courts here in Delaware, there is what they call a pro se office. And there is someone in that pro se office who can actually help take a look at the situation and provide the non-custodial parent with the materials to file that modification. If you are a custodial parent and not a client of the divisions, you too can go to the Pro Se office and they will help you file for a modification. But our clients, if you're a client of DCSS's, we will do that on your behalf. If you think you should have a modification because it's been 2.5 years or there's been a substantial change in circumstances, call us and let us know that, and we will take those steps. We have our child support system, the Delaware child support system, has an alert system that should have notified the worker, hey, this order is coming up on 2.5 years. But if the worker hasn't gotten to that alert yet, feel free to reach out to us, and we will take those steps. Let's see here. Okay, the next question is, what if the non-custodial parent deliberately flies under the radar with payments under the table, so purposely there is no income to provide or prove? Is it up to the non-custodial parent to prove it with a PI? I'm not sure what that means. Or is there any protocols you do? Okay, a couple things here. And I always, from time to time, talk about people who work under the table, or people who support non-custodial parents who support themselves by illegal means. So those are some of the most difficult cases that we have here at Child Support, because it's really up to non-custodial parents to pay that obligation on their own. There's no employer to send that wage withholding to make that automatic deduction to their paycheck. It's hard for us to get that non-custodial parent to make those payments. If a non-custodial parent owns their own company, it's hard for them to it's hard for us to get that non-custodial parent to make those payments on a regular basis. Some non-custodial parents who own their own company, they do make the payments. Sometimes it's sporadic. Sometimes they're right on time. I don't want to disparage, those private business owners who are not custodial parents who are doing the right thing. But those cases where they work under the table, it's extremely hard. There's only really a couple tools that we have when non-custodial parents either own their own business or working under the table, supporting themselves by illegal means, and that is to file continuously to file contempt petitions with the family court. Now, with business owners, we can suspend a business license that would, that could affect their company. Sometimes when their companies are owned with other individuals, it becomes a little bit more difficult to do that. Now, so that's one piece of it. The other part of this is proving income at hearings. So, sometimes people who are going to family court, they think they're going to outsmart the court system, or they think they're going to outsmart the child support system. What the court will do is this, and this is one of the things, if you've seen any of my videos or you heard me on the radio with Jake Smith on those third Wednesdays, we spend a lot of time talking about don't ignore child support. If you get a letter from the family court, if you get a letter from the Division of Child Support Services, don't ignore it, because if you confront it, you look at that letter, you answer that phone call from the child support office, we will, there's things in those letters that can help you maneuver through this child support system. But the point that I'm trying to make here is this. In those letters that come from family court that says you have a hearing, they often put information in there like you need to bring your pay stubs, or you need to bring a tax return or some other form of financial proof of what you earn. And when an individual doesn't bring that information to the courts have no other process or no other reason to just look at the labor standards. So what they do is they say, sir, you are the non-custodial parent. You didn't bring your pay stubs. The labor standard says that for someone who earns or performs this kind of work, you earn, the labor standards here in Delaware say you earn X amount of dollars per week or per hour. And we are going to attribute what this labor standard book says to your child support obligation. So when I go to level 4 facilities in the state and talk to the incarcerated or go and talk to community groups, I say, don't don't throw that document out. Don't not listen to it. Bring your financial statements to the court. Bring what they tell you to bring. Fill out the forms that they tell you to fill out and submit to the court. Because, for both parents, you don't want to be attributed for earning more than what you truly earn. So, if you're a construction worker and they say construction workers in the state of Delaware earn $20 an hour, we're going to attribute that because that's what the labor standard says. But if you only earn $15 an hour, they're going to create an order that's more than what you earn. And, that's why you need to provide that documentation. So some of our enforcement tools work when people work under the table or not, are supporting themselves by illegal means. But really, filing continuous contempt petitions with the court, mandating that they find employment, the courts can do that. There's really, it's so hard. Those are some of the hardest cases because we can't attach those wages. I often talk about the employers. The employers in the state of Delaware and child support agencies around the country. 75% of all the child support collected around the country comes from employers, deducting it from an individual's wages and sending it to the child support office. So, the employers play such an important role in helping us collect child support. So if someone is working under the table, it's so hard to get them to comply. So I'm just going to read this statement and thank you again. I really appreciate the nice things that people are saying in this, and the best thing that you can do for us, and I'll say it one more time, is share this and the reason why we hold it from 11:30 to 12:30 is hoping that people are, like, if they're working, they can go to their car and log into Facebook on their lunch break and listen to us, or listen to us at their desk while they're having lunch and learn a little bit about child support. So we purposely hold these events the first Monday of every month from 11:30 to 12:30 during the lunch hour, so that people can maybe take a break from their places of employment and tune in. So this is really great. I'm so happy for the amount of comments and questions that have come in today, and this just reestablishes to me here that this is something we need to continue to do. And we talk about it here in the Director's Office of Child Support, how important this is to people in Delaware, and we really want to keep going with this. So in response to what we're talking about with people working under the table, this is wonderful, fantastic. You have resources to do when non-custodial parents has income under the radar and are self-employed. Again, I praise you for the changes you've made. Is there a charge for non-custodial parents to keep filing contempt of court? So we will file with the court. Any petition that we generate here at Child Support gets reviewed by the family court. Gets reviewed by the Department of Justice. They are our attorneys, and they will review the case along with us and sign those petitions. So, and submit them to the family court. So, we certainly, we will file a contempt petition anytime it's warranted. And one of the things that I failed to mention about when we continuously file those contempt petitions with the court and the Department of Justice approves those petitions, a family court commissioner who keeps seeing the same non-custodial parent and their flagrant disregard for the previous order, or their flagrant disregard for making regular child support payments, the only thing that's going to do is make the family court commissioner become upset. that the non-custodial parent is not following their order that they put in place previously. The more times a non-custodial parent goes before the family court commissioner, it then becomes a more serious, obviously a more serious situation, because the courts, although they don't like to do this a lot, and they try to explore as many alternatives, but they do have the right to incarcerate someone for non-payment of a child support order. So, sometimes I try to encourage non-custodial parents that, hey, if you can make a payment continuously, make some kind of a payment, even if you're unemployed, or if you're own your own business, or you're working under the table, you can make a payment on a regular basis, and that will help your cause as you continue to have to go before the family court. So, certainly it's important to the family unit that non-custodial parents try to comply the best that they can. Look, we all face in our lifetime financial circumstances that may not be the greatest, but if you can continue to make that effort, it goes a long way. And quite honestly, I think that more custodial parents would find themselves being a little bit more understanding to a non-custodial parent who is making an effort to make those payments on a regular basis. So I always try to preach that to non-custodial parents. Try to make a payment on a regular basis. And this writer continues, I'm even more impressed that you go into the prisons to educate the incarcerated individuals. You are educating and forming a rapport with both groups so trust can happen. And you're so right. It's important that we try to gain the trust. Non-custodial parents tell me all the time, I'd come to your office, but you're gonna incarcerate me, or you're going to arrest me, and that just doesn't happen. So, when we changed our division's name back in 2015, we tried to make a concerted effort, and this is what we're continuing to do 8 years later here, is to make that concerted effort to reach both parents, because that's really what's in the best interest of the child, to reach both parents and work closely with them to make sure that child support is coming in on a regular basis. So thank you all for these great comments. This is excellent. I think I've gotten through all of them. I'm just going to do a quick scan to make sure. But if you know someone who wants child support, you can always refer them to our customer service unit. You can refer them to our website. I always like to talk about our website too. Our website has great information for anyone who needs help with child support. Custodial parents, and I often encourage non-custodial parents, employers. There's tons and tons and tons of great information on our child support website. We are, we just have so much information, and we want people to take advantage of that. And being able to look at our website and try to find information, everything from how to apply for child support, and they can do that online, or ask us and we will send them a paper application that they can submit and return to our office. And we have so many different tools, and it definitely talks about our enforcement tools and what each of those tools do and how we go about enforcing child support here in Delaware. So we certainly want people to take advantage of it and have that information. One of the other things that we are starting to do, and I first must say this, if you have a cell phone number or an email address, the next time you call child support or want more information about your child support case, we're always asking people to give us their email address or give us their cell phone number, because we are embarking on a new way of communicating with custodial and non-custodial parents, and it's called our Proactive Client Notification System. This has been a tool we've been putting in place probably now for about 1.5 years, maybe a little bit longer, and this will allow us to communicate with custodial and non-custodial parents by email, and text messaging. And if you've already got an email in our child support system, you probably already got a welcome email from us, and it gave you information about enrolling in our customer website. But our proactive notification system will do things like tell a custodial parent, hey, we are dispersing a payment to you. Or it will say to the non-custodial parent, hey, we haven't received a payment from you and it's time to make that child support payment. We will notify custodial and non-custodial parents when there's a court hearing. And it will give us an opportunity to just send messages of importance to the custodial and non-custodial parent about their child support case in Delaware. So the proactive client notification system, if we don't have your email address or your cell phone number, please give it to us because we want to be able to communicate from you. We want to be able to communicate with you using those two ways, email or text messaging. Now, custodial and non-custodial parents, you can opt out of it at any time. If you don't want to receive messages from us, you can do that and opt out and opt back in when you're ready to. But it's just one way for us to be able to work with our clients and be able to give them information about child support as it specifically affects their case. And but you have to enroll in that customer website in order to do that. And so you may have gotten a message from us, a welcome message, and like I said, you can opt out at any time. But that's something we are so super looking forward to, being able to communicate with our clients, both custodial and non-custodial parents, on a regular basis. So if we don't have your information, please give it to us, and we will add that to our system. So let's see here. I always like to also use this opportunity. As you probably suspect, one of our priorities is to make sure that children that are born in Delaware have paternity established. So paternity being established for children is so important. And basically what that does is it makes sure that the child's birth certificate has both parents' names listed on it. And we will do that through 3 ways. So if you know somebody whose child if you know someone who has a child and both parents are not listed on that birth certificate, give us a call because we can help make that happen. It's so important for the child, not only for economic reasons, medical reasons, but social reasons. Knowing who both of their parents are, being able to identify with both parents, it's so important for the growth of a child. And helping us establish paternity for children born in Delaware helps do that. When we talk about economics, if that child's parents were to pass away, being able to receive Social Security benefits for that child from the deceased parents' Social Security benefits, it can't be done unless paternity is established. And we all know about medical, basically knowing what the parents' health issues are, genetics, and passing that down to children. There's medical reasons. It's vitally important that the children know who both parents are. Now, paternity in Delaware is established in 2 ways. Well, technically 3 ways. The first way is by marriage. So if the parties are married when the child is born, paternity is automatically established for those children. But I like to talk about the Voluntary Acknowledgement of Paternity Program. The Voluntary Acknowledgement of Paternity Program deals with a document, and it's called the Voluntary Acknowledgement of Paternity Form. When both parents want to acknowledge paternity, I know I'm the biological mother, I know I'm the biological father, they both can sign off on that Voluntary Acknowledgement of Paternity Form and have it notarized. We will notarize it at the Child Support Office for free. And the Office of Vital Statistics, they will notarize it for free. Actually, probably any state agency would notarize it for free. But the parents sign off on that voluntary acknowledgement of paternity form, submit it to the Office of Vital Statistics, and both parents' names will be added to that birth certificate for that child. There's no cost. We will help you do it here in any three of our three child support offices in each of the counties. We will help you do it, and we want to help you do it. So if you know someone, if you're a grandmom or a granddad watching this video and you know your grandchildren, their paternity is not established, speak to your children and have them do it. Voluntarily acknowledging paternity is a simple process, and it's free of charge. The next way is through genetic testing. We here at Child Support can help people get genetic testing done with the help of LabCorp. We can do it, schedule it for mom, the child, and the putative father to have genetic testing done. The family courts can also have genetic testing ordered. But we want to help people get genetic testing done. It's no longer, I always joke about it now, it's no longer through drawing blood or any of that kind of stuff. It's taking a Q-tip or a swab and taking a sample of the inner cheek of both parents and all of the children involved, and they send those samples to a lab, and if the test results come back 99.99% that putative father is the biological father, his name will be added to the birth certificate, and paternity is established. But one of the things that I failed to mention about the voluntary acknowledgement of paternity is the key word, voluntary. If either party does not feel that they should sign off on a document, we do not want you to sign it. Call us or speak to a child support employee, and we can help you get genetic testing done. But it's purely voluntary. Another comment just came in. Let's see here. Great information about paternity establishment. Glad to hear acknowledged for social and medical reasons as well. Also about death benefits, something that happens to parents. I can't tell you, I could probably count multiple times where one of the parents has died recently, and we've had to kind of scramble a little bit to try to figure out how to get paternity established for children. It makes so much sense to get it done sooner rather than later. Thank you for all those great comments. I really appreciate it. Here's a new question. How much does an absent parent or absent father need to owe before the law gets involved? So I'm going to read that again. How much does the non-custodial parent or father need to owe before the law gets involved? So this is the thing. It's kind of a tricky question, because child support, what we want to do is this. We want to make sure that people are paying their court-ordered obligation and on a regular basis. We certainly understand that in life things change. People lose jobs, and then payments may not come in for a little bit. But ultimately, if the non-custodial parent is doing what they need to do to continue to make those payments or make some kind of a payment when a circumstance changes, the law or the child support agency really isn't going to get involved. But it's only when things go sideways and go bad, really bad, where non-custodial parent fails to make regular payments or continues to make regular basis on a long period of time, there's no dollar amount that can be associated with that. It's just non-compliant, being non-compliant with the child support order. So I always try to talk to non-custodial parents about doing the best that they can to make those regular payments. Because if a non-custodial parent is making, when we talk about regular payments, making them consistently. If a non-custodial parent has an order for $200 a month, but then loses their job and is actively trying to pursue a new job and can only make $100 a month, to me, that doesn't warrant the law getting into effect, going to bringing somebody back to court, because that non-custodial parent is doing what they're doing the best that they can to continue to make some kind of a payment. One of the things I always try to tell people too is this: if you're a non-custodial parent, it's better to call us at child support at the customer service unit telephone numbers to let us know, hey, I lost my job, but I'm trying to find a new job. Maybe we have some suggestions on how to help you find a new job. But it's better to be upfront with us and let us make a case note in our child support system. Hey, spoke to the non-custodial parent. He lost his place of employment. He's looking for work. We referred him to a couple places that are hiring. We can put some case notes in our system, so if we hear from the custodial parent, we can let them know. Or as a non-custodial parent, you too should be speaking to the custodial parent about changes that you've experienced. Open communication with the child support program and with the custodial parent on behalf of a non-custodial parent is key to making sure that everybody's aware of what the circumstances are. Half the child support cases that we have that non-custodial parents are non-compliant in could have gone totally different if they communicated with us at child support, or they communicated directly to the custodial parent in advance of a situation going bad. And really that's really the key, is being able to communicate with the parents. What if the mother knows that the absent parent is working under the table and he has not been paying for years, owing over $7,000? Can the mother sue him? The custodial parent can take someone to family court for child support at any time they're not receiving a child support payment. If there's no order, they can go ahead and bring that person into court for child support. If they're working under the table and they're not receiving child support and there's a court order, yes, they can go back into family court saying, I'm not receiving child support. And the non-custodial parent would have to answer to the court about why they're not making regular child support payments. So yes, the non-custodial parent can be brought to family court for not paying for years. Absolutely, the parent can be brought into brought into family court. So I see that time is up. What I'm going to do is, before I conclude, I want to again thank you, everybody. Thank you so much for the questions, the great comments, the praises of some of the things we're doing here at Child Support. I really do appreciate all the great things that we talked about today. Check out our website. If you're not enrolled currently in our customer website, check it out. It gives you the ability to create a username and a password and actually have ways to communicate with your child support worker through that customer website, as well as receive information, print account statements electronically at home. But check out our customer website. That's so important for people to use. And then I'm going to give you our customer service unit telephone numbers. Again, it's 302-577-7171. And if you have any questions about child support, please call us at our customer service unit. They want to help. And then I will be back next month, June 6th, the first Monday of the month, from 11:30 to 12:30 on the Child Support Connection. Tune in the third Wednesday of every month. I'm on 92.7, 98.5 WGMD with Jake Smith. We take questions from the public, so if you have questions, feel free to call in and ask that question. We certainly appreciate the calls from the public and being able to share child support information here in Delaware. So thank you very much, and I will see you next month on June 6th. Take care, everyone.